So good afternoon, everyone, and welcome to Estate Administration Week. My name is Noel Xavier, and I am the Director of Donor Services with Edmonton Community Foundation. It is my pleasure to be your host for this session, and we are so happy that you could join us. Many of you are already familiar with our annual Wills Week, held every October. This week, we're launching a new series of presentations, similar to those you've attended for Wills Week, but with a specific focus on the ins and outs of effectively administering an estate. At the Edmonton Community Foundation, our role is to help people create their legacy for our community. We are a trusted resource for Edmontonians to provide ongoing endowment support for the charitable organizations and issues they care about. As a result, we have many conversations with people in our community about their wills and estate plans. And we know how important it is for people to learn valuable information from wills and estate professionals. Just before I introduce our presenter for today's session, I would like to let you know that at the end of the session, you will be given the opportunity to fill out a survey. As this is the first time we are hosting Estate Administration Week, your feedback is valuable to us and it will help us to plan for next year. Today's session is being recorded and it will be available by the end of the month on our website at www.ecfoundation.org. So you are welcome to come back and watch the videos again or share them with friends and family. I'm going to ask that if you've got questions for our presenter, to please put them into the Q&A feature, which is at the bottom of your screen, depending on which version of Zoom you are using. Please enter your questions in there, and we will hold the questions until the end, and then I will go through and ask them to our presenter. And so now to introduce her. So I'm very pleased to welcome Anna May Choles. Following an undergraduate degree in honors political science at the University of Alberta, Anna May earned her law degree in 2011 from the same institution. As a law student, Anna May gained critical legal research and analysis skills by working as a student researcher for the Centre for Constitutional Studies and the Alberta Law Reform Institute. During this period, she complemented her studies by volunteering at Student Legal Services in the Civil and Family Division, at the Edmonton Kids in the Court program, and at the Golden Key Honor Society as a mentor for the English Key program. Since being called to the Alberta Bar in 2012, Anna May has gained comprehensive experience in advising clients in various legal areas, such as wills and estates, real estate, and corporate commercial law. She continues to remain active in both her legal and broader communities, and currently serves as a co-chair of the Elder Law section of the Canadian Bar Association, Alberta North. Anna May has previously served on the board of directors for the Elves Special Needs Society and as a volunteer for Junior Achievement. In her spare time, Anna May enjoys ultimate frisbee and hiking. So I want to thank Anna May so much for generously volunteering not only her expertise, but her time to present this presentation to you today. Over to you, Anna May.
Thank you very much, Noel. As Noel said, I'm Anna May Choles. I am a partner at Rackel, Belzil, LLP, and today we're going to be discussing some common issues in estate administration. So to begin with, I'd like to start with a couple of definitions to make sure that we are all on the same page. First off, one of the definitions is going to be estate assets. So by that, it means basically what it says, all of the assets that form part of the estate of the deceased. That may not necessarily be every single asset owned by the deceased at the date of their death. There may be assets that they had that fell outside of the estate because they had named beneficiaries or were jointly owned. Although some of those are not guarantees that it means they fall out of the estate. There may be a situational specific analysis to say, is that part of an estate asset or is it not? But broadly, we're talking about estate assets being what the executor is responsible for or the personal representative of the estate. So next, grant of probate. It's one of the most common terms you hear. Do you need probate? Do you not? A grant of probate is a grant issued by the Court of Queen's Bench of Alberta, which affirms the will and says this is the last will of the executor. Of the testator or the deceased. So it's the last will of the deceased, and it also affirms the authority of the executor. It says this is the person who is entitled to administer this estate. However, a grant of probate only applies when there is a will because it's confirming that will. In a situation where the person who died does not have a will, they are said to have died intestate or without a will. And in that case, you cannot get a grant of probate. What you would be obtaining instead is a grant of administration, which confirms the authority of the person authorized to act as administrator for the estate. Then lastly, what do I mean when we talk about estate administration? We're not going to be talking about all aspects of estate administration today, rather just some issues that can arise. But with estate administration, what we mean is the process by which the personal representative of the estate, who can be either an executor under a will or an administrator under a grant of administration, identifies, collects, maintains, protects, and ultimately distributes the assets of the estate. This can involve selling assets, paying debts, filing taxes. All of that is part of the broad category of estate administration and are the duties of the personal representative of the estate. So the issues that we're going to be discussing today are the following issues. So what are the issues that arise when you're administering an estate without a will? So when someone dies intestate or without a will. Then we're going to move on to some foreign matters. What are the issues that arise when you have foreign beneficiaries? And by foreign, we mean both outside of the province of Alberta and outside of the country of Canada. Can be two different sets of issues. What if the estate has assets that are outside of the province of Alberta or the country of Canada? What do you do then? Then we're going to talk about when things are missing. If we can't find a beneficiary, what do we do? If we can't find an asset we think should be in the estate, what do we do? Then deceased or incapacitated beneficiaries. And lastly, we're going to talk about insolvent estates. So insolvent estates means that there are more liabilities than assets. So there's more people who need to be paid than there's money or assets to pay them. What does the executor do in that circumstance? Firstly, we're going to talk about administering an estate without a will. The biggest issue with intestate estates or with administering an intestate estate is that the very first thing that has to be done is figure out who actually is going to be in charge. One of the most significant benefits of a will from just an estate administration perspective, ignoring, distributing to beneficiaries, is a will says, this is who's in charge. This is my executor. I am saying my cousin Bob is going to manage my estate for me. That doesn't happen when someone dies without a will. Now, there's legislation that can follow, and there's a priority list in the Estate Administration Act of who has the first right to apply. But the complicating factor of that is it makes it complicated for third parties. When an executor goes to a bank to say, okay, this person has died, I need to know information about their estate, they usually take two things: the funeral director's statement of death, proving that the person has died, and the will, proving that they have authority to act. When you don't have that will, how does the bank have confidence that you're the person they're supposed to be talking to? There are privacy rules. They can't just release information to anyone. They need to know that the person they're talking to actually has that right. So that's one of the biggest struggles, is not knowing who's in charge. The other struggle with that is there are circumstances in which case it's not always clear who's the best party to act. So there's a priority list in the Estate Administration Act. And it says, okay, first it's going to be the spouse or adult interdependent partner, then any adult children of the deceased. Then if there are minor children and no spouse, then it'll be the public trustee's office, then the parents of the deceased, then their siblings, then nieces or nephews. So to a certain extent, where you might have a spouse or adult interdependent partner, that's not as complicated as some of the other scenarios. One of the issues that causes a lot of problems is if you have a person who dies without a will and they do not have an adult interdependent partner or spouse and they don't have any children. So now the estate falls to their parents to administer. This can sometimes be a very difficult situation. Sometimes the parents are not in an emotional or mental situation to be able to deal with their child's estate. They never expected to outlive their child, and they just can't manage it at that point. Sometimes what this means is we might have to get the parents to renounce in favor of a sibling, or someone else will be able to take on that responsibility on the parent's behalf. But all of this takes time, and getting people to sign documents and doing all those other things that need to be done. The other issue that can arise is if the parents have predeceased, now it goes to the siblings. Well, what if there are a number of siblings? What if they don't all get along? What if everybody thinks they're the one that should be in charge? What do? There are certain priorities in the Estate Administration Act that can assist in identifying it. For example, siblings who reside within the province of Alberta have priority over siblings who don't. But ultimately, this can add time and especially cost, because you might have a little bit of a squabble. You might have a fight that might delay things. There might be some litigation while people decide who should be in charge. And all of that, again, takes time and it takes money. And it also can take mental and emotional toll on all the potential beneficiaries of the estate while this fight goes on. Another factor that makes administering an estate without a grant of where there is no will more complicated is that there is no authority until that grant is issued. When a person dies with a will, the executor named in the will has the authority to act immediately upon that person's death. They have the right to take care of the body, they have the right to prepare the funeral, they have the right to take over right away. They don't need any more proof other than that they have the will and the death certificate. Now, ultimately, you may have third parties like the land titles office or the bank that say, given the size of this asset, I'm going to require you to get a grant of probate in order to allow you to access this asset and administer it. But technically, the executor's authority starts not from the grant, but from the will. So as of date of death, they have the right to make decisions. Not so with an administration. Because there is no will, the administrator doesn't have any technical authority up and until the date that the grant is issued. That's the items from which they get their authority. In Alberta right now, it's taking us between 5 and 6 months to get a grant through the court. That could mean 5 or 6 months where no one is able to control or manage the assets the way they should be. Sometimes it's not a matter of getting money from the bank, but it might be a matter of going to the bank and saying, look, we're not trying to take any money out. I know we have to get the grant of probate, but let's look and see what automatic prepayments we can keep going. Let's make sure the mortgage payment can keep going. Let's make sure the utility payments can keep going. Let's make sure the insurance payment can keep going until we can get the grant of probate to sell the house. An administrator can't do that. The bank won't necessarily talk to them. Sometimes it's even an element that they can't get the basic information from the banks about what is the amount of money in the bank accounts to prepare the grant of probate. Often the banks prefer to get a letter from a lawyer saying, okay, this is this person's authority. We've done the necessary considerations. There's no one who takes priority above them, and that's the situation. But the essence of an intestate estate and the common issues that arise with it is that it can be slower. There can be risks that those assets aren't being properly managed. There's no one to give instructions about investments, even holding everything steady until the grant has been issued, and that's when the administrator takes authority. So there's delays and there's additional time costs, and those are some of the issues that arise when we don't have a will. And that's why, and I'm a wills and estates lawyer, so this is one of the things that I harp on, but it's one of the fundamental reasons why it's just so much easier to have a will. Because even if you have a very small estate, you think, oh, there's not that much there. Actually, it might be more critical to have a will in that case, because with a will, even if it's a very small estate, we've got a clear person who's in charge, we've got a clear level of authority, and the banks will feel, and other third-party institutions will feel much more confident releasing information and assets when there is a clear will in place, as opposed to when we're just waiting on a grant. So next, we're going to move into some foreign issues. So out of province or out of country assets or beneficiaries. Firstly, we're going to talk about foreign beneficiaries. And there's two broad categories of issues for foreign beneficiaries. One is that there are tax issues, and the second is just that there are some complications. When you have beneficiaries who reside in Canada but outside of the province of Alberta, that's usually not a huge deal. There can be some issues wherein different provinces have different estates laws and different rights of who can bring claims or who can have an interest in the estate that might cause some friction because each beneficiary is going to want to base their stuff on the law of the province where they're located. So that can be a friction. But largely the bigger issue is communication, especially when we're dealing with out-of-country beneficiaries. So we have to serve every beneficiary by mail. That takes a little bit longer when you're dealing with people outside of the country. If you have beneficiaries who do not reside in a country that's primarily English speaking, that can be a bit of an issue because all the documents are in English. And so it may be frustrating or confusing for them, or they may have to go and get it translated to find out what's going on in the documents. If as executor you want to have an estate meeting and get, okay, well, there's this issue, I want to talk about it, I want to sit down with all the beneficiaries to discuss what we're going to do next. Having a beneficiary who resides outside of Alberta or outside of Canada and is in a different time zone can make that more complicated. Now, with two-way video conversations, it's a lot easier, but it can just frankly make it more complicated from a time zone perspective of how do you get everyone in the room to make a decision. The executor might have the ability to make decisions on their own, but it's not a bad idea to talk to beneficiaries and say, okay, do you have any separate concerns about this? Open that channel of communication to make sure that if there's beneficiaries are becoming uncomfortable or concerned with something, they bring that to the executor right away, and the executor can deal with that concern right away rather than letting it fester and become a significant problem. One of the other members of Wills Week has a saying that I very much enjoy, which is silence is suspicion. When the beneficiaries aren't hearing from an executor, that's when they get concerned. And having beneficiaries who are outside of especially the country of Canada can sometimes make it more difficult to communicate with them and therefore make some of these issues more significant and might require greater efforts from the executor to successfully communicate. We also have potential tax issues. Again, not so much for beneficiaries who are outside of the province of Alberta, but beneficiaries who are outside of the province of Canada, or sorry, the country of Canada, do have tax issues. It's a situational specific analysis based on the type of asset they're receiving from the estate, but typically foreign beneficiaries would be subject to a non-residence tax. And they would have to file with CRA a non-residence tax form. But before they do that, the estate has to pay a withholding tax to CRA, because CRA doesn't have jurisdiction over them as residents not of Canada. And so what that means is that CRA says, no, before you send the money to them, send us our share. They file their taxes and they can get the money back from CRA. That makes things a little bit more complicated. And as executive, you might think, well, it's not my taxes, what do I care? Well, you care quite a bit, because as an executor of an estate, one of the biggest areas of potential liability is tax liability. If there are any taxes that it was the estate's responsibility to pay or the deceased's responsibility to pay, and you distribute without making sure that those taxes are paid, then what that means is you can be personally liable for those amounts. And that includes a withholding tax. It is a duty on the state to pay the withholding tax to CRA. And if you don't do that, and then the beneficiaries don't file their taxes and file the non-resident tax forms and manage all of that, then you're personally liable for the tax that would have been due. So you want to be very careful about those sorts of things, because there's a lot of areas of potential liability here for the executor. So next, we have foreign assets. So when an estate owns an asset that is outside of the province of Alberta or the country of Canada, what can those assets be? It can be a bank account in another country. It can be a vacation home in Arizona or a timeshare in Mexico, any sorts of those items. I've broken this down into two broad categories: practical issues and legal issues. One of the biggest practical issues is it's very hard for an executor who's in Alberta to successfully take control of, let's say, a vacation home in Arizona, especially right now with COVID. You can't actually go there. So what that means is that the executor might have to hire someone to help out. They might have to hire agents to go and look into the property, take an inventory of the property of what's in the property, if there's any household goods, any personal effects, anything else in the property, and have that information sent back to the executor. Then after that, you're going to have someone check on the property so that we're keeping the insurance up, we're making sure the taxes are paid, we're making sure the utilities are kept up. It's just more complicated. Also, if there are assets that are located outside of especially Canada, often what that means is that taxes are going to have to be filed in that country. So that means you are going to have to hire an accountant who either has knowledge of that country's tax system, or hire an accountant in that country and get those taxes filed before on dealing with any asset in that jurisdiction. That doesn't always necessarily mean there's taxes that have to be paid, but quite frequently there are taxes that have to be filed, even if there's no amount that has to be paid. And again, as the executor, because you've got that personal tax liability, you want to be very careful to make sure that is all done completely properly. So those are some practical issues. It's just harder to manage things that aren't where you are. And you might have to hire people to help you do that. The legal issue is this: a grant of probate is specific to the province in which it is issued. The grant of probate or the grant of administration is issued by the Court of Queen's Bench in Alberta. It doesn't necessarily go over provincial borders. So if you have a person who dies in Alberta, but they also own a piece of property on Ontario, what that means is you will have to, if they were resident in Alberta, you get the grant in Alberta, then you're going to have to take that grant and get it resealed in the province of Ontario. So bring a separate application in Ontario to reseal it. That might mean that you're having to pay additional probate fees or taxes. Alberta has one of the lowest probate fees. All the other provinces are a lot more than us. Most of them are a lot more than us. So there may be significant additional fees that the beneficiaries may not be thinking of. You might have different laws in those provinces as to the beneficiaries or who has to get notice. And then you're going to have to comply with the specific provincial laws or the laws of the specific other country as to who has a right to notice, what claims can be made against the estate, what claims can be brought. In Alberta, we typically only give notice to the beneficiaries under the will, the spouse, any children under the age of 18, any children between the ages of 18 and 22 years who are attending post-secondary on a full-time basis, any children who are unable to withdraw from their parents' care by reason of mental or physical disability, any grandchildren where the person was standing in place of a parent, and one of those categories applies, and the spouse or adult independent partner of that person. And then we may also have to advise the public trustee's office based on who else we're advising. But that's not the rules in other provinces. For example, in British Columbia, you're supposed to give notice to everyone who had a right to inherit on an intestacy. So if you had a family member who was disinherited, but would inherit on an intestacy, and we've got an asset in BC, now we have to give notice to that person. Now we've got potentially a fight. They might have different rights to bring claims in different provinces. It just makes things far more difficult, and there's potential for different issues. Also, now you're probably more than likely having to hire a second lawyer in the correct jurisdiction to give you legal advice specific to that jurisdiction. Also, occasionally, and this is not as significant an issue, you can run into different rules with regard to what constitutes a valid will that can cause problems. Usually these can be surmounted if the grant of probate has been issued in a court already. But sometimes it can cause just some logistical issues or difficulties. One additional issue from a intestate succession provision perspective, so where someone dies without a will, is if they have a spouse and then children who are not from that relationship, who are not the children of the spouse or partner, then under Alberta law, they have the spouse has the right to the first $150,000 in the estate, or alternatively 50% of the value of the estate. In Ontario, that preferred share is actually $200,000. So if we have a person who dies intestate and they have a spouse or partner and they have children from another relationship, does that mean that that spouse gets to claim the first 150 in Alberta and the first 200 in Ontario? So they get $350,000? And that can be a live issue that people can fight about. Now, typically the courts have said no, they just get the higher of the two preferred shares, but it's a potential issue that could arise that people could fight about. There could be extra working claims that come as a result of this. Now, as an executor, you can't necessarily prevent that, but it might be in your best interest to communicate that to the beneficiaries, to say, okay, we've got these assets in foreign locations. We might run into these issues. You need to be aware that we're not going to be able to complete the administration of the estate until we deal with this asset in Arizona or Ontario. It will delay the estate, and just keep the beneficiaries informed so that they understand what the potential issues are and what the costs are and why it's taking so long. I have one estate where we have to reseal our grant of probate in Jamaica because the deceased had a house in Jamaica. And that is just a long process that's holding up our ability to complete the rest of the estate, because that has to be dealt with first. Foreign assets just cause, there may be significant value there, they may be lovely and wonderful, but they can cause a lot of delays and a lot of extra costs. And it's important as executor that you communicate that to the beneficiaries so that they don't see any additional time and cost as being as a result of something you've done wrong, rather than the natural circumstances of having estate assets that are not located in Alberta. So now we're going to go on to our missing categories. What do we do if we can't find a beneficiary or we can't find an asset in an estate? Missing beneficiaries are a very complicated subject. It's complicated in an issue on a couple of different levels. Firstly, there's a service issue. Secondly, there's frankly a distribution issue. How do you distribute if you can't find the person? But the first issue is that in the province of Alberta, we're supposed to send a notice to every beneficiary who inherits under a will or under intestate provision or under the intestate succession provisions on us filing the application for a grant in the court. So if you can't find a beneficiary, what do you do? So, well, the things you do is you try to find them as best you can. You talk to family members, you try and track down every bit of information you might have about a person. You try looking for them on Facebook or LinkedIn or any other social media site. You do everything you can do. What information do we have? Did someone have their phone number? Do we have an old email address? Can we try and track them down? Then the other thing that happens is if we can't find them, then you often have to hire a private investigator to go and look for the beneficiary. Not being able to find a beneficiary doesn't mean that their interest in the estate just gets automatically dissolved. You have to put in a significant amount of work as executor to try and find this person. Now, if that is holding up the administration of the estate, there is a possibility of filing what's called an NC-27 form called missing or unknown beneficiaries. Sorry, it's an NC-25, not 27, NC-25 form called missing or unknown beneficiaries. And what that allows you to do is to say to the court, okay, we need to administer the estate. It's urgent that we do so. We can't find this beneficiary. Here are the reasonable steps we've taken to try and locate them. Now, we also undertake to advise the court as soon as we find this person and to provide the notices that need to be required to them at this time. But we need to get that grant of administration or probate because we need to start dealing with these assets regardless of the fact that we can't find that person. So that's what you can do if you can't find them on service. But if you keep going through the administration of the estate and you still can't find them, well, then you have two options and neither of them are particularly good. But before we get to those two options, one of the things you need to think about is you're the executor. Typically, you provide an accounting to the beneficiaries, and then they approve that accounting and they sign releases and you distribute the funds. Or if someone doesn't approve the accounting, you might have to bring an application to pass accounts. Well, if you've got a missing beneficiary, you probably have to bring an application to pass accounts because no one can approve your accounting. There's no beneficiary there to approve your accounting. So you're going to have to bring that application. Then secondly, there are two basic options with what to do with the missing person share. The first one is to have them formally declared a missing person and under the Public Trustees Act and have the money paid to the public trustee. you can't just send it automatically to the public trustee. You have to first have them declared a missing person, and then the money can be paid to the public trustee. The other option, which is appealing but is much more difficult to accomplish, is called a Benjamin order. What this does is, in a situation where a beneficiary has been missing prior to the date of the deceased's death, you might be able to acquire an order to have the court deem them to have predeceased the deceased and died without issue. So what that means is that their share in the estate can be redistributed back to the other beneficiaries in the estate. I have not personally done this. I do have one of the lawyers in our office who has done it. In that case, it was a very complicated situation, but it was a situation where the deceased had died in the late 1980s. He had been married in the 60s and had had 2 children. After the parents divorced, the mother took the children back to Scotland. And then no one in Canada ever heard from them again. There was also an indication that the children's last names might have been changed, and no one had a very firm idea of what the correct legal spelling of the wife's name was. No one had heard or seen from them since the 1960s. And we did have beneficiaries in Canada. This was an intestate estate. We did have beneficiaries in Canada who could inherit. So on that basis, and after we hired a location service and a private investigator and a genealogist and did absolutely everything, we tried to look in Scotland for them. After all of that, ultimately the court did say, okay, you've proven the burden. We think that we're never going to find these people, and we'll deem them to have predeceased and allow you to distribute the assets to the beneficiaries in Canada. But it took a long time. We had to have it was a high standard to prove, a lot of work to prove that. And it's not an easy order to obtain, because you have to be able to justifiably say to the court, I think there's a chance this person predeceased the deceased. So if they disappear at some point during the administration of the estate, which does sometimes happen, a Benjamin order won't help you because you know they didn't predecease. All right, so now we're going to move on to missing estate assets. So sometimes you run into a situation where there's an asset missing in the will that no one can find, or one of the beneficiaries says, well, I thought mom had a bank account here, I can't find it, or it's not mentioned in the estate inventory, what happened to it? And it depends what sort of asset they are. So if the will said, I give my teacup to my niece, it's strongly possible that that gift may just have a deed. And what that means is either she gave that teacup away during her lifetime, or it was destroyed, or it was destroyed, and that no one's going to find the teacup, and we'll just have to say, I'm sorry, there's no teacup for you to receive because it doesn't exist. But with bank accounts or investments or shares or financial assets like that, it's important to do more digging. So what that might involve is reviewing documents and bank statements and old tax returns to try and figure out, okay, when was the last time the deceased claimed income from this asset? Do we see evidence that it was ever sold? Were there capital gains claimed on it? Can we see any evidence of it existing? If we can find some of that, then maybe we know when to look to say, okay, well, was it sold? Did it just get added into joint names? And was there any malfeasance, or was there perhaps a genuine gift to someone or a genuine sale and the money went into another bank account? If there's a concern that there was some malfeasance or assets that were claimed to be joint when maybe they shouldn't have been, then there might need to be some litigation and some efforts to trace the funds and see what happened with them. But as the executor, you do want to try and find all potentially missing income so that you can make that estate, the assets in the estate, as large and much and significant as possible. And that's one of your duties. So sometimes things just go missing and no one can find them. And so to that end, I have named 2 different ways to look for money when you can't find it there. So first off, the Bank of Canada unclaimed balances. If a bank account sits dormant for a period of 10 years or more, the funds on the account are often sent to the Bank of Canada to be held. If the funds are less than $1,000, they are held by the Bank of Canada for up to 30 years. If it's more than $1,000 in the account, then it is held for up to 100 years. That's sort of how the Bank of Canada works. There's a link there. You can follow it. You can search your name, see if there's anything for you. Ultimately, you provide them with a copy of the grant and proof that you're the person who has authority to access this account, access this information. Once you provide them with that evidence, they will send the money to you. It takes a little bit of time, but it's a perfectly workable system. Then we also have the Alberta Unclaimed Property Registry. So in Alberta, sometimes this is not specifically for bank balances, but it's for other assets, maybe investments, maybe shares, maybe, there's physical shares that went missing and then we need a place to report it. Alberta Unclaimed Property Registry, missingmoney.com/e/. You can again go and look there, search your name, see if there's anything in your name. Sometimes assets that people didn't know their parents still had show up there, or that they didn't know that they still had show up there. And so it's not a bad resource to check to say, okay, well, I've done my due diligence as an executor. I know that there's no unclaimed balances. I know that there's no unclaimed property. Just taking a look, it never hurts. The next thing we're going to talk about is deceased or incapacitated beneficiaries. So firstly, for this, we are assuming that the beneficiary survived long enough to inherit. So they had to survive the deceased before, and then they died after the deceased. If they died before the deceased and it's a will situation, then typically there is either an alternate beneficiary named in the will, or there might be a lapsing provision that applies, but it really depends on specifically how that will is worded. If it's an intestate succession matter and someone predeceased, then you go down the next section in the intestate succession provisions of the Wills and Estate Act and find out who the next beneficiary is. But presuming the beneficiary survived the deceased, survived long enough to inherit, and then died before the estate was finished being administered. Then how we manage that is not dissimilar how we manage it when someone is incapacitated. What we have to do is find out who has the authority to make decisions on behalf of that person's estate and communicate with them and manage any distributions through them. So what are you going to need? You're going to need some proof. You're going to need to see that beneficiary's statement of death. You're going to need to see their will, ideally, so we know who the executors who we're talking to, or a grant of administration if they don't have a will, so that you have confidence as the executor of the estate that you are communicating with the correct person, that someone's not going to show up and say, well, I don't know why you were talking to my brother John. I'm the one who's in charge. You shouldn't have ever given him any information or anything. Similarly, when someone is mentally incapacitated, so they've lost the ability to make decisions, then we obviously cannot serve documents on them. If you serve documents on a person who has dementia, that's just incredibly unfair. They're not going to know what they're doing. It's what they're receiving. They might not understand what's going on. It could just be genuinely distressing for them. So in that case, what you have to do is get confirmation that the person has actually been deemed to be mentally incapacitated. So you want to see the doctor's notes, and then you would communicate with their attorney under an enduring power of attorney if they have one, or their trustee, their adult trustee under an order of trusteeship in Alberta. That's called different things in different provinces. It's a guardian of property in Ontario. But you want to see that court order saying this is the person who has been appointed to make the decisions for this person who can't make decisions for themselves regarding their property. And if they say, oh, I don't have one of those, well, then they're going to need to get one, because you need to have confidence that you're communicating, and especially when distributing assets, to the correct person. So it's not just good enough to take someone's word for it. You have to physically see the documents. And that might mean that you're seeing emailed or scanned copies, but you need to physically see the documents to confirm that they have the authority to act. And then once you know that that person has the authority to act, whether it's on behalf of an estate of a deceased beneficiary or on behalf of a person who has lost the capacity to make decisions, then you can communicate with them. They can sign the necessary releases, and they can receive the money on either the estate or the incapacitated person's behalf. All right, so now we're going to move on to insolvent estates. When an estate has more assets, more liabilities than assets, or more debts than assets. So firstly, we're going to talk about the priority of debts. The very first priority debt that exists is funeral expenses and costs. That's the very first category of bill that needs to be paid. In fact, you can usually take the funeral director's bill directly to the deceased bank account and have them pay it directly. That's an absolute priority that has to be paid. Then after that, the next priority is testamentary costs and reasonable estate expenses. So that can include things like legal costs, accounting costs. Now, if there's not very much money in the estate or there's not enough money to pay all the bills, you want to be very cautious that these are reasonable in the circumstances, but it's still a priority claim. Then we have executor's compensation. That falls under the category of testamentary costs and can come above debts that have to be claimed. Lastly, we have debts that are secured by an asset. So if we've got a mortgage on land, that mortgage has the right of priority over that asset. If there's a security agreement registered, that's a PPR registration, that security agreement will have a right of priority on the proceeds of that asset when sold. After that, everyone, including CRA, takes on a proportional basis to the amount of the debt that exists. So if there is $100,000 worth of debt and only $100 worth of assets, everyone's getting 10 cents on the dollar. And they get their relative proportion of that $100,000 debt, but they're only getting the 10 cents because that's all there is to give. Where you want to be very careful is that there's a lot of potential for liability for executors here. You don't want to start paying debts right away. The funeral expenses are one thing because that's a priority debt. But if you're at the funeral and someone is coming up to you saying, oh, my good buddy Earl, he owed me some money, you don't want to be paying that right away. You might say, okay, well, you're going to send me your information about it and we will assess that debt. The reason you want to be careful about that is if you pay off that debtor, that claimed debtor right away, and then it turns out there's not enough money for everyone else, then you have preferred that debtor over everybody else, and you now have personal liability to those debtors because you shouldn't have paid any debts until you knew exactly how much money there was to go around and that there'd be enough money to pay all the debts. The other thing that you want to be careful about is you need to get actual proof of the debt. So this is not so much an issue when you're dealing with third-party institutions. They can usually say, hey, I've got this credit card bill, I've got this other expense, I've got a promissory note that they signed, I've got a security agreement. But if you just have someone who comes up to you and says, well, this person owed me $10,000. Well, you need to see some proof of that. Did they owe them $10,000? Is there anything in writing? Because otherwise this is just a bold claim. Also, you're going to need to look at timelines. There is a Limitations of Actions Act in the province of Alberta called the Limitations Act. If and it has an ultimate 10-year limitation period. So if this person is saying, well, this person borrowed money from me in 2008 and they died in 2021, well, I'm sorry, you're out of time. You don't have a valid claim anymore. You needed to bring your claim within 10 years. There's also a limitation of 2 years after they knew or ought to have known of the potential claim. So you want to be careful that the only debts you're paying are valid debts and that they're valid enforceable debts. You also want to be careful when you're putting together that pro rata distribution. You don't just say, oh, there's $100, here's everyone's 10 cents, I'm calling it a day. You need to get that distribution, show that distribution to the debtors, show them the statement of what the assets are and say, okay, before I send you any money, everybody's got to agree to this distribution. I'm not sending anyone money till we've got that agreement. You also are going to need to let the beneficiaries know, and you may want to get them to sign an acknowledgement that they understand that this estate is without asset, that is, this estate is insolvent and they won't be getting anything at the end of the day. Sometimes people are very optimistic about how much money should be in an estate. They hear an estate and they get considerably optimistic about how much money is going to be there. They're sure that their Aunt Helen, their great Aunt Helen, was sitting on millions. And you're like, well, no, as it turns out, there was, in fact, barely enough to pay the bills here. So it's very important that, again, you're communicating that with the beneficiaries to say, here, I'm setting your expectations. There isn't going to be enough money. We got to pay $90K to CRA. There's not going to be any money to distribute, and that they acknowledge that so that you don't have problems later on. So that is the essence of the presentation that I prepared. We now have time for questions, and I believe that Noel, you're going to assist me with the questions.
Correct. That's right. Thank you very much. I always learn so much from you, Anime. And actually, you mentioned something specific that I think you and I are going to have to chat about after this call. So, but I'm not going to monopolize the question and answer. We do have a couple of questions. So just a reminder for our listeners here, if you've got a question for Anime, please type it into the Q&A feature, which for most of you should be at the bottom of your screen, depending on the Zoom version that you've got. So my first question for you from our listeners, Anime, is actually there were two questions about foreign beneficiaries who are minors. Is there anything our listeners need to know about for foreign beneficiaries that are minors?
Yes, when you have any beneficiary who is a minor, you have to give notice to the Public Trustee's Office of Alberta. And that is regardless of whether or not the fact that they reside in the province of Alberta or not. The public trustee also has to be served with a copy of the application. Now, how you manage from there really depends on the beneficiaries and whether or not, and how it's set up in the will. Is there a trust clause in the will? Is there a trustee named in the will? If there isn't, you may be having to pay that minor beneficiary share to the public trustee's office to keep and manage until they turn 18, even if that's not the age of majority in the location where the minor beneficiary is. If there is a trust clause and there are parents or a guardian who's willing to keep an eye on things on behalf of the minor beneficiary, the public trustee might just say, okay, that's all I needed to know. I'm washing my hands of this. We're going to back off and just let this happen. But it really depends, and let the guardian and the executor work on it together. But it really depends on exactly what that will says. If it's an intestate succession, if there's no will, the money's got to go to the public trustee's office.
Okay, great. Thank you very much. We've got a couple of other questions here. From a tax perspective, so I'll read, as far as taxes go, how do you prove that the person has passed away?
From a tax perspective, really, the funeral director's statement of death. You often are sending to CRA a copy of the funeral director's statement of death. Sometimes a notarized copy, you might go to your lawyer and get that notarized, along with a notarized copy of the will if possible, to say, this person has died. I need you to send any further information to me at this address because I'm the executor for the estate. That being said, from a tax perspective, the biggest sign that this is going to happen is for the taxation department is that you're going to have to file a terminal T1 for the deceased. So you file a tax return for them up to the date of their death for one of the tax years, and then everything that happened after the date of their death is estate taxes. But before that, that is covered in their terminal T1. Great,
thank you very much. That's great. Actually, we had a couple of questions just at the end, one slide back from the question slide here. PPR registration, a couple of people were asking, what does PPR registration stand for? You had it in the insolvent, yeah.
It's a personal property registry. So in Alberta, if you have a lien that you're registering against a motor vehicle or any assets or any debt that you're securing by personal property, and by personal property I mean that is not land. So land is real property in legal terms. Everything else is personal property. So if you're securing it by a general security agreement, you're securing against people's vehicles, that gets registered at the personal property registry in Alberta. And you can do that through either a lawyer's office or an agent or registry's office. Registry's office, if you want to go and search your own name, they can help you do that. There's a cost, but they can search your name and make sure that there's no extraneous registrations out there for you.
Great, excellent. Here's a question about compensation for an executor. Can you speak a little bit about what is that? Some people might not even know that executors can be compensated.
Fair enough. So the general assumption is that an executor does have a right to compensation. Now, there is nowhere in a strict formula for what the amount of that compensation should be, because estates differ significantly. An estate takes time and effort and mental and emotional strain, and frankly, organization and time on that executor. And it is a job that should be compensated. There's no set structure for how that's going to happen. It usually has to be approved by the if it's not set out in the terms of the will, then it will have to be approved by the beneficiary, and failing that, by a judge. The general range is about 3 to 5% of the value of the estate. Now, what is appropriate in the circumstances really depends. How big the estate is, how complex the estate is. You know, did the executor have to manage any litigation? Did they have to deal with property? If it's just bank accounts and all they had to do was liquidate some bank accounts, pay the bills, file the taxes, and then distribute the money, maybe that's not as worthy of a high level of compensation as it might be if there's, you know, a business that has to be dealt with and houses that have to be sold and lots of stuff going on. So, and I've said this a couple of times, and I'm sure it's not a very happy answer, but it's a situational specific determination. It depends on what the specific situation of that estate is. That being said, you also want to be aware that executor's compensation is taxable income and it is subject to all standard employment deductions. So there's going to be a deduction for income tax, should be CPP, EI, all those standard deductions will apply to any amount of executor's compensation.
Well, great, thanks, Anna May. Does official notice to the beneficiary have to be given if the executor is also the attorney for the incapacitated beneficiary?
So, incapacitated, for the incapacitated, yes. But what I would typically do in that circumstance is, if the executor still has to give themselves notices of all that they would have to give under the application for probate. So the notice to themselves as the beneficiary, the notice to themselves if they were the spouse or adult or dependent partner or anything like that. If you're the attorney and the executor, what we typically do in that circumstance is just give you the notice, but instead of sending it to you by registered mail, I just have you sign a copy that acknowledges that you received a copy of the notice. I give you one, you sign an acknowledgement, and that way we don't have to spend the extra money on registered mail, because the court has confirmation that the attorney for the incapacitated beneficiary did in fact receive that.
Great, okay, thank you. We talked about foreign minors a few minutes ago. We actually had a couple of questions about foreign minors. There's another question here. Is there an age of majority, or is there a minimum age where someone can receive an inheritance?
In the province of Alberta, it's 18. You can't receive any money till you are over the age of 18. If you're to receive any money before that, it's going to be paid to the public trustee's office. Now, a will might set out a higher age for a trust to say, okay, I don't really want my grandkids to get their money when they're 18 years old. I just don't think they're mature enough. It's not a great life example. So the will might say, okay, well, it's going to be held in trust till they're 25 or 23 or 21. And then the money is held in trust till that date by the executor or the trustee named in the will. But in an intestate succession perspective, in an intestate estate, it's always going to be age 18.
That's great. I like this question, short and sweet, and no one likes to pay extra taxes, but can you expand on the priority of the CRA? You've talked about that being a priority. Why?
So the CRA, it depends on the circumstances. So if the CRA has registered a writ against a piece of property, they might have a higher priority because they've got a registration. But typically, if they don't have any registration where they've claimed a prior claim, they are a general debtor or a general creditor, and they are paid their proportion of whatever proportion of the they form of the debt of the deceased out of the assets of the deceased. Now, that's only in an insolvent estate situation. However, if there is more than enough money to go around, if there is enough money that we can pay all the debts, you have to pay all the debts.
We've got a question about a beneficiary dying after the deceased. But then there's, I know you've talked about having sort of alternative beneficiaries. So can anyone make a claim against the deceased beneficiary's share?
Well, it depends. So if, and it depends on if they survive long enough to inherit. Lots of the times in wills, you will see a survival clause or something like that that says, okay, any beneficiary who dies within 15 or 30 days of the date of my death will be deemed to have predeceased me. And so that's supposed to set up a time limit. So if the beneficiary doesn't survive, so if the beneficiary survives and the time limit is 15 days, if they die 10 days after the deceased, that share goes back into the estate and gets redistributed as per the estate. If they survive longer than that, then their share goes to their estate. And so if there was a spouse or child or someone else who would have a claim against their estate, then they would have a claim to that deceased share of the estate through that estate. Does that make sense?
I think so. We'll find out. If that didn't answer your question,
let us know. I'm sorry.
Yeah,
I
put that
realized
back in. Yeah, but I think so. Based on how I read the question, I believe that answered the question. Yeah, thank you. Yeah. Here's an interesting one. Can a grant of administration be applied before the person's deceased?
No. No.
Short and sweet answer. There we go. Yeah. Any advice about personal effects like jewelry? Should they be sold first and then added to the estate? What's your advice for things like that, like jewelry and personal effects?
It depends, which is everyone's favorite answer from a lawyer. It really depends on the circumstances. So first off, often there is a clause in the will that says, here's how we're going to deal with my household goods and personal effects. And if there is that clause, then the executor would follow that clause. Otherwise, if there isn't a clause dealing with household goods or personal effects or any jewelry that forms part of the estate, then often what we'd have is a situation where the beneficiaries would want to purchase the jewelry from the estate. And so a beneficiary could use their share in the residue of the estate, so all the money that's left over at the end of the day, to say, okay, I want grandma's ring, and we will have to value that ring to make sure we're getting the correct valuation for it. But say, I want grandma's ring, and I'm willing to take less money because I'm taking the ring as part of my share of the estate. I would suggest doing that and seeing if the beneficiaries have any interest in purchasing the jewelry from the estate before you set it up for just to sell it in any other way. You're probably going to get the most money from the family because they have the most interest in it. And also it just prevents you having problems later on. If someone did want to buy grandma's ring and you set it out, the sale out on the open market, and now it's gone, you're just going to have long-term problems because that person will never be able to get over it. Will quite possibly never be able to get over that, and they'll always be upset about it, and it'll cause you problems down the road. It's a lot easier to try and communicate with the beneficiaries and say, hey, you tell me if there's any of this that you want. If multiple people want the same things, sometimes what we do is a blind bidding situation where everyone bids what they think it's worth, what they're willing to pay for it. And then once the bid's closed, the lawyers open the envelopes and say, okay, this is the highest bid, that's the one we're going with. So there's a number of different ways you can deal with that.
Okay, that's great. You had spoken about property outside of Canada. Are there any extra problems to watch out for if that property, the foreign beneficiary is also jointly named on that property? Anything? Does that change what you spoke about earlier?
So it can, because if the foreign beneficiary is jointly named on the property, it's going to depend on the specific rules of that jurisdiction. Does that mean that they were joint with the right of survivorship? Because if so, that asset goes directly to the foreign beneficiary and doesn't form part of the estate. Not all joint ownership is joint with the right of survivorship, and it depends on how they did it, and if there was any subsidiary document, what the relationship between the foreign beneficiary and the deceased was. It can depend on a number of factors, and mostly it depends though on what the law of that jurisdiction is. So if they're jointly owned, it can mean it's not part of the estate and would go just directly to the foreign beneficiary.
Great. Okay. And for those clients that you deal with that do have foreign assets, do you think it's better to liquidate those assets before death and then bring the funds back to Canada? What I know, again, it depends probably, but yeah, what do you think about that?
It depends, and it also depends on how significant your foreign assets are. So there are circumstances where what I've recommended to clients, and sometimes this is what I do recommend to clients, is if they have significant assets in another jurisdiction, so they lived part of their life in England and they still have significant assets in England, they might own a home in England, it might simply be easier to have two wills. And you can set up a will to say, this will is for my Canadian assets and my other will is for my worldwide assets, or vice versa. This will only deals with my English assets. This will deals with my Canadian and worldwide assets. And the reason you might want to consider that is twofold. Number one, you can have different executors who are set up to properly manage the property in that location. You're not subject to the same amount of delays, because instead of having to wait to get a grant in one jurisdiction and then take that and reseal that in another jurisdiction, you can do it simultaneously. But you have to be very careful that you do this correctly. So you want to make sure that what you're doing when you have multiple wills is that they are consistent with each other, and that there aren't gifts given twice or missed or something along those lines, or one beneficiary who's supposed to be in both wills isn't inadvertently not in one, that the second will doesn't accidentally revoke the first. So you want to be careful, because usually the first clause of a will is a revocation clause. But there can be a genuine benefit to having multiple wills for assets in multiple jurisdictions. That might be one way to handle it. The other question about whether or not you should liquidate the assets before their death, it depends on the nature and the amount of the assets. It genuinely might be easier. The American taxation system can be very difficult to deal with, and I'm not an accountant, but if you have American assets and they're not significant, but maybe you own a house or something like that in another state, it might be easier to liquidate that if possible before your death. Getting at that point, of course, the proper accounting advice, how to best limit the tax consequences of doing so and how to best manage that.
Great. We talked about compensation for the executor. Are there any set fees for having a trustee manage the estate?
It depends what you mean by trustee. So if what you're talking about is a corporate trustee, so a trust company, RBC Trust, CIBC, Canada Trust, BMO, I think I've got all, CWB. If you're talking about that sort of a trustee, they all have their own preset forms, or Scotiabank, that was the one I missed. They all have trust companies who will manage your estate for you. They have their own preset forms of what their percentage is of that they will take as compensation, and that is a pre-agreed to matter. If an executor wants to have the trustee act, the trust company act for them as executor in all administrative matters, they can do that. But then that would be taken out of, usually that's taken out of the executor's fees. The executor would then not receive compensation because they've hired this agent to act. And then again, it's based on what the fees are that that trust company would particularly charge.
Okay, great. Yeah. The questions are actually coming in faster than I can ask them. So the number of questions isn't going down. That's great. That means a lot of people have want to learn a lot more. So that's great. The next question is, can you repeat what you said about the timing of filing taxes for a deceased person?
Oh, okay. Certainly.
That's important for everyone to know. So a good recap. Yeah.
Yes. So with taxes, you have to be aware that as the executor for the estate, you are responsible for filing the deceased's final tax return, often called a terminal T1. And what you do is that tax period covers January 1st to the deceased date of death in their year of death. So what that might mean is that tax return might only cover, January to April if they died this week. It might cover a lot more if they die later in the year. But that's, as well, there are other things to be aware of with the terminal tax return. That's when RRSPs, any tax consequences of that come in, tax consequences of shares that are owned, capital gains, that all has to be dealt with on your terminal T1. So I would like to emphasize, if you're an executor who's looking at dealing with this, it's very important that you hire an accountant or a tax specialist to help you. A tax preparer, in my experience, does not typically have the experience necessary to successfully do that. I would strongly recommend you get an accountant, because it is more complicated than me filing my own personal T1. On the death, it's more complicated for taxes. But the taxes for the deceased to their date of death are filed on that terminal T1 form. Every piece of income that comes after that is filed on a separate return called a T3 return, which is an estate return.
All right. Great. Okay. Thank you. That's great. This is a question maybe for Will's week, but I see that there could be maybe some confusion, so I'm going to ask it here. Can a couple have separate wills? What are the advantages and disadvantages? I know you talk about this at Will's week, but yeah. So
it depends what you mean by separate wills. Every individual should have their own physical will. There is a concept called joint wills where both couples sign on the same will. To my mind, that's not very good. It just leads to significant problems down the road. You can't do that unless you're either a married or common law couple, but I would suggest you don't do that. What's better is that everyone has their own will. And frequently between spouses or partners, we have what's called a mirror will. So what that is it's a will that are basically essentially mirror images of each other, except for switching out the partner's names. So it's where the couple sits down and goes, okay, I want everything to go to you, you want everything to go to me, and then we're going to agree on what happens next. We're going to agree on, if something happens to both of us, who gets the kids, who gets the cat? What if something happens to us and the kids? Who would get it to share then? How do we divide the money between our families? And that's what's referred to as a mirror will. So you should have your own documents, and then ideally you would both meet up with a lawyer to do that. Now, sometimes couples can't agree to do this, or maybe one member of a couple is unwilling to go and get their will done. Sometimes people think that they will die once they get their will done, and I can assure you, you will die anyways, whether or not you have a will. So
fair enough.
sometimes they have different wills because they're drafted differently, but it's easiest if you sit down and decide with your partner, what would you both want? Who would you want to both take care of? If you're going to have trust for the kids, how are those trusts going to operate? It's much better because then it limits problems down the road, and you can have a cohesive estate plan where, okay, we've sat down and thought about what happens if one partner dies? Is everything well set up for that? And then we've thought about, what do you both want for your kids? How long should they wait till they get their money? Who should be in charge of that money? Who should take care of them? So it's generally recommended you go with your partner if at all possible, but if your partner is unwilling to go, you should still go and get a will done.
Sounds great. All right. How does the executor handle cash flow that continues to come in after death, like TFSA monthly payouts, income from rental property, dividends, etc.?
So an executor should open an estate account to manage that. They should have an account where the money can go into directly. Sometimes it's a matter of managing the money that's already in existence, but if there's money coming in, you should open an estate account and put that money in the estate account. As the executor, you're going to have a duty to account to the beneficiaries for all the money that came in and all the money that was spent in the estate. So it's easier to just start that off right away with, okay, what's the money coming in? I've got that clearly documented. I've got it clearly shown in a new account, and I'm going to make the payments as they come out. Also, once you have that grant of probate, typically what happens is you cash out and close those accounts that were in the deceased's name and transfer them into this new account. Not necessarily with investment accounts. Sometimes we keep those open because we might want to distribute those in specie to beneficiaries. We might say, okay, everyone takes a quarter share of the investments rather than cash them all out. But again, that's specific determinations based off of what both the executor and the beneficiaries want to do in that circumstance.
Excellent. Great, thank you. Let's talk about that final tax form. Is there a time frame that executors need to be mindful of?
For the T1, the T1 terminal return is due either on April 30th of the year following the date of death, or if the person dies after October 30th, 6 months from the date of death. So you get a little bit of extra time when a person dies late in the year in order to allow the executor some extra time to manage these things. But one of the things you do want to think about, if the deceased is a person who is receiving any government benefits such as CPP and OAS, you want to make sure that you let them know as soon as possible that the deceased has died. And again, it's just a matter of sending that death certificate and the notice, because if they make payments past the month of death, then you're going to have to reimburse them later on. So it's easier just to prevent that from happening.
Sounds great. Just a couple of more questions here. Can you appoint a law firm as an executor rather than a family member? What would be the advantages, disadvantages?
Typically, you don't appoint a law firm. You might appoint an individual lawyer, and it would depend if that lawyer was willing to act. Every lawyer has a different practice on this. I typically don't act as executor on my clients' estates as much as possible. The role of lawyer and the role of executor is very different. They wear different hats. And in fact, if you are using a lawyer as your executor, that executor may need to still hire a separate lawyer at their firm to represent them and give them the advice that a lawyer would give. There's an old joke about a lawyer who represents himself has a fool for a client. That applies regardless of what situation it is. When you're the executor, that is one hat. When you're the lawyer for the estate or for the executor, that's a different hat. Typically, where I recommend people go if they think either my family is not going to be in a good situation to manage my estate, or there's too much conflict. I don't think that picking any one child or sibling is going to be a good idea. Generally, I recommend that people head to a trust company. And often your bank will have a trust company. Almost all of them do. Even ATB, I didn't mention it, they don't have a specific ATB trust company, but there's a trust company they work with. That's probably a better direction to go than a specific lawyer. Now, if you have a good long-term relationship with your lawyer, then it might be a position where you can ask them to act as your executor because they have the background and knowledge. But it's going to be up to the lawyer whether or not to act. Typically, you can't appoint a whole firm because that's not, other than corporate trustees, you typically want to have it's going to be an individual who has to act. Okay, great.
Now, there's one more question. It's actually for me. So before I answer that, I've seen that there are quite a few questions that are very, very specific. And so obviously the question is coming from a very unique case, often about jurisdictions outside Alberta, et cetera. So because they are very unique, I won't ask them in this forum because we've got over 160 people here, but you see on your screen that Anime's contact information is there. The questions that I'm seeing that are very specific might require a longer answer, so I would invite you to please reach out to Anime so that she could give you proper case-specific answers rather than going through some of those things here. But the last question that I want to answer, thank you, Cindy, for asking, when is Wills Week? So this is now a plug for the Edmonton Community Foundation. So I saved it for last on purpose. So Estate Administration Week, as you know, is happening right now. This is our third session, I think, Anime, right? We had 2 sessions yesterday. We've got 6 more sessions for the rest of the week. You can find them on our website. It's right here by my shoulder. Oh, this way. Sorry, I'm mirrored. www.ecfoundation.org. And you can register for sessions there. But Wills Week, it takes place in October. So we will have the dates and the sessions confirmed towards the end of the summer. And again, you'll be able to find that information at www.ecfoundation.org. For those of you that have not attended a Wills Week session before, very similar format to what we're seeing here today. Anime will be back with a session, but instead of focusing specifically on estate administration or executors or chasing down foreign beneficiaries, it's much more general about the importance of having all of your estate documents in place and some things to think about when you're putting your will and your other estate documents in place. So again, if you've got a very specific question, I invite you to reach out to Anna May. And thank you so much, Anna May, for your presentation. I always really enjoy hearing what you've got to say. I learn a lot every time. I hope that our listeners have learned a lot as well. And I want to thank you all for joining us today.